Morning, everyone. Representatives of Petrotrin, representatives of the Ministry of Energy, representatives of the press, members of the committee. I'd like to welcome everybody and to reconvene this meeting and welcome those present, as well as the viewing and listening audience, to the 7th meeting of the Joint Select Committee on State Enterprises. This is the committee's second public hearing pursuant to its inquiry into Petrotrin. I would like to remind everyone that this broadcast is being broadcast live on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. Members of the viewing and listening audience can send comments or questions via email to parl101@ttparliament.org or on our Facebook page at facebook.com/ttparliament or on Twitter @ttparliament. I have a housekeeping note here. I've been asked to make sure everyone has their phones either off or on silent so that we don't have any disturbances during this session. And I would like to invite the representatives of Petrotrin to introduce themselves and members to the committee. Mr. President.
Thank you, Mr. Chairman, and good morning to you and members of the committee. Thank you for having us again, and I will ask the members of the team to introduce themselves, and then I'll just make a quick comment about the absence of the chairman, who is not here this morning.
Good morning, Chairman and committee, and to the public. My name is Neil Derrick. I am the Vice President, Human Resource and Corporate Services, acting.
Good morning. My name is Ronald Huff. I'm the Chief Financial Officer.
Good morning. I am John Barden, the Vice President, Refining.
Good morning. I am Radhika Murad Singh, Senior Manager, Law and Land Management.
Good morning, Mr. Chairman and members of the committee, viewing audience. My name is Stephen Auer, and I'm the Vice President, Exploration and Production, acting.
Thank you. I'd like the representatives of the Ministry of Energy to identify themselves, please.
Good morning, Chair and members of the committee. Selwyn Lashley, Permanent Secretary at the Ministry of Energy and Energy Industries.
Good morning all. Leroy Mears, Energy Consultant at the Ministry.
Thank you very much. Let me just go through the introductions of the members of this committee, beginning with members on my right.
Good morning, Adrian Lyons, the member.
Good morning, Alison Bash, member.
Morning, Fazal Karim, member. Yes, good morning. My name is Wade Mark, member.
Morning, Brigadier General Ansel Antoine, retired, member.
Good morning, everyone. I am David Small. I'm the chair of this committee. I want to place on the record that the chairman of Petrotrin, Mr. Andrew Jupiter, has communicated with the committee, and he is properly excused from the meeting. He communicated with the committee, indicating that he is overseas on official government business, on an official government business trip, and the committee has communicated back to the chairman, indicating that he is excused to the meeting. So we want to make sure that that is publicly recorded, that the committee understands that Mr. Jupiter, why he couldn't be here. So we have no issue with that whatsoever. I would now ask the chairman, the president of Petrotrin, just make a few brief opening remarks before we begin our session.
Thank you, Mr. Chairman. Again, we are happy to be here again to go through the deliberations of the committee and to respond to inquiries so made. Let me just quickly establish a basic understanding of Petrotrin, which we think we would use as a basis for all the questions we have to answer. Petrotrin is an integrated oil company, and we think it's important to keep reminding people of that. And really, we make our revenue from the production and marketing of refined petroleum products. As a result, for us, it's important that we produce some crude, which is used in the refinery, and we source the remaining crude. And the refined products are what we sell to produce our revenue for the company as well as the profitability of the company. In that regard, it's important to recognize that when crude prices are high, we gain a significant competitive advantage by producing our own crude. But when crude prices are low, the issue becomes a very intractable one, and we find ourselves where sometimes it could be a bit indifferent, but we continue to do what we need to do in terms of increasing our crude production. That is our model, and everything that we do with respect to our business revolves around that model: sourcing crude, refining it, producing refined products, selling those refined products into our customers and the various markets. That is our opening statement, and at this time we are available to the comments and questions of the committee.
Thank you very much, Mr. President. Before we begin the questioning, the members of this committee have asked the chairman to deliver some remarks or some comments or a statement. And it has to do with a disturbing trend that is apparently emerging or probably is now coming to light regarding the way in which the responses to the committee have been coming. So I want to spend a couple of minutes with the permission of all to just go through a short statement, which again, all members of the committee have mandated the chairman to make. Good morning, the citizens of Trinidad and Tobago. The committee views this statement as becoming necessary because of the actions or behaviors being demonstrated by some state enterprises. The effect of these actions is that the authority of this committee is being challenged, and that if we allow it, then state agencies will be allowed to dictate what information they provide to the parliamentary oversight committees, all under the guise of protecting their interest. The question that obviously arises then is that if they are owned or controlled by the state and they are seeking to apparently circumvent the authority of the parliament, whose interests are they really protecting by these actions? For the information of all, this committee derives its authority from Section 66 of the Constitution of Trinidad and Tobago, which is the supreme law of the land. At Section 66A3 of the Constitution, I wish to quote, "Subject to this section, the standing orders of the Senate and the House of Representatives shall apply to a committee appointed under this section." At Section 66A, Roman 2, paragraph D, and I quote, it says, "Enterprises owned or controlled by or on behalf of the state or which receive funding from the state of more than 2/3 of its total income in any 1 year," and and E says, "in relation to their administration, manner of the exercise of their powers, their methods of functioning, and any criteria adopted by them in the exercise of their powers and functions." I want to take the time to quote also from the standing orders which flow from the constitutional authority of this committee. I want to refer all present to Section 91 of the Senate standing orders. And under that rubric, it says general functions of departmental joint select committees. At Roman B, it says the committee is required to investigate, inquire into, and report on all matters relating to the mandate, management, activities, administration, and operations of the assigned ministries, departments, or bodies. At 101 of the standing orders, under the heading General Powers of Select Committees, in addition to the powers granted by these standing orders, Select Committee shall also have the following powers. And at A, it says, namely, to send for persons, papers, and records. At 102 of the Senate standing orders, under the heading Procedures in Select Committees, the exercise of the power, under the heading, the exercise of powers to send for persons, papers, and records. At subparagraph 12, it says, a select committee may require by order that a summons be issued to any person, A, to attend before that committee, to be examined and give evidence, and B, to produce papers and records in that person's possessions, custody, or control to the committee. Similar provisions are to be found at Sections 101B, 111A, and 112.11 of the House of Representatives Standing Order. I, as chair, has been mandated by the members of this committee to make very clear our understanding and our expectations when information is requested from state entities. The filter for this information is the committee. The filter for this information is the committee, who will take fullest consideration of any entreaties regarding confidential, competitive, or legal considerations proffered by the entity in conducting our work. It is not the purview of entities to determine what information this committee should have access to or not have access to. It is the considered view of this committee that there is no discretion by the entity being examined regarding legal requests of this committee for information to conduct our work. The emerging trend of spending taxpayers' monies to get legal opinions that have the effect of limiting this committee's authority to access information is not going to be tolerated. At least one entity has gone the route of quoting case law on a particular matter as their excuse for refusing a legal and mandatory request for information. The committee has been advised that in July 2014, the High Court ruled that a ministry acted illegally when it refused a request from an entity for documents related to a contract to develop a public property in Port of Spain. That ministry had claimed it was exempt as the items were confidential legal advice and bound under all sorts of legal opinions. The local High Court ruled that the ministry had failed to prove its public interest concerns against disclosing the advice. The committee trusts that there will be no recurrence of this errant behavior. To the citizens of this country, I give you the assurance that this committee is fearless, but fair, and will be seeking to get the fullest accounting of the expenditure of state resources by entities under our purview. There will be no states within a state under the watch of this committee, and any entity that fails to adhere to these guidelines will have to return and tell the citizens of Trinidad and Tobago on live TV why they are trying to not provide information to this committee and ultimately trying to avoid information being provided to the country. I want to thank you for allowing me to proffer the committee's position on this matter. And in closing on this statement, I want to say that the committee is here to provide recommendations. The outcome of these inquiries is a report in which recommendations are included. If entities choose to decide not to provide specific bits of information that are material to the committee having an opinion, then all the committee can say is that the company or the entity didn't provide the information, and the committee here is hamstrung in giving an opinion. So that these matters are matters that are of grave concern to this committee, given the fact that this committee is empowered by the Constitution. And we take serious exception to having state entities writing to us and quoting case law. Or we take serious exception to that. A request has been provided, it should be fulfilled. Confidentiality of information is guaranteed by the Parliament, and there is precedent. Entities have appeared before this Parliament before and have said we have information that we deem to be commercially sensitive, legally sensitive, and all that has happened is that those entities have asked to have those matters discussed in camera, away from the glare of live TV. But there was no issue of not providing information. We have an issue with entities deciding for themselves to not provide information to this committee. So I want to thank everyone for allowing me to share the committee's concerns on this matter, and we trust that those entities that have information outstanding for this committee will do the right thing, because there will be some action that will be taken if it is not provided. I will now open the floor for questions to begin the session today. I understand Senator Mark would like to begin the questioning. Senator Mark, you have the floor.
Yes, thank you very much, Mr. Chairman. And may I welcome all the officials, including the President of Petrotrin, to this Joint Select Committee on State Enterprises. Before I enter into some of the areas I would like to have clarified, I would like to put on the records of this Parliament my surprise, almost disbelief at the conduct and behavior of such an important state entity in TNT and its failure to provide information to this committee. As the chairman said, we are here to help, not to hurt. We are here to submit recommendations to make Petrotrin more efficient, more effective, and more economical. But it is inexcusable, it is indefensible for Petrotrin to advise this committee that based on legal advice and referring us to court cases, they will not be able to supply this committee with documentation that has already been supplied to the Law Association of Trinidad and Tobago. Our Attorney General has provided all the legal opinions that that Petrotrin is refusing to provide to this constitutional body, having regard to the fact that this body is established under Section 66 of the Constitution of the Republic of TNT, which is the supreme law of the land, and it supersedes the Legal Profession Act. So I'm very disappointed, disturbed, flabbergasted over this development. And I hope that Petrotrin would reconsider its unfortunate position. Before Petrotrin leaves this hearing today, I am hopeful that this stance taken by Petrotrin would be reversed in the national interest, and we do not go further with this matter. I would like to ask the President whether this position that was taken had the blessings of the Minister of Energy and Energy Industries, or was this a unilateral decision on the part of Petrotrin not to supply this committee with opinions that are now in the hands of the Law Association of this country, that the Attorney General has supplied upon request and has indicated that any organization that requests these legal opinions, he is prepared to consider supplying same to those organizations. So I would like to have some clarification whether this is a unilateral decision on the part of Petrotrin, or whether this has the blessings of the Minister of Energy and Energy Industries. That's the first clarification I would need to have, Mr. Chairman. The second area I would want to get into, there are several, but I want to deal with a few before passing on to my other colleagues. In your submission, you indicated, and I quote, by application dated 12th of January 2016, filed on the 13th of January of 2016, and as as well as a supplemental affidavit dated and filed on the 15th of February 2016. Counsel Debadine, I think it's Varun Debadine, applied to the court to cease to act as instructing counsel. That is in your Appendix 8 of your earlier submission. First of all, was any reason given by the counsel, Debadine, for ceasing to act? Secondly, who comprised the board of Petrotrin at the material time the decision was taken to file a lawsuit against the former executive chairman? And how was the decision to hire the respective counsel or counsels determined by the board? And as you are on this matter, I will just ask 3 final questions in this round. Could you provide this Joint Select Committee with information on who was the alternate chairman at the meeting that Mr. Professor Andrew Jupiter recused himself? That would have been on February the 18th. Could you also provide to this committee information on the names and positions of the other persons who constituted this meeting? What was the rationale used for determining the decision to discontinue the matter by the board? What was the overall cost lost to the company, including all legal fees, in this matter? And finally, Mr. Chairman, through you to the President, could you confirm for this committee, Mr. President, who hired Counsel Varun Debadine to represent Petrotrin? These are some of my early questions I would like to have clarification on, and I think that this committee would like to have some clarification on, Mr. President of Petrotrin. Thank you, Mr. Chairman.
Mr. Chairman, thank you. We note the 7 questions from the Senator, and I will attempt to speak to the first one and also respond to the general issues. And then I will ask the Corporate Secretary to respond to the other legal matters. Yes? So with respect to the first item, I want to just draw your attention to our submission the last time we were here. And there was one question that spoke very specifically about how does the company carry out its daily operations and how decisions are made. And in that we were very clear in identifying that we are operating under a governance structure that includes a board and a management. There is no opportunity in certainly our obligations under the Companies Act for the minister to be involved in day-to-day activities of the company. And so decisions that are made by the company are not in any way influenced by the Minister of Energy. And that is fundamental to how we operate as a company within Trinidad and Tobago. Because we are a state enterprise, yes, but we are a state enterprise who are incorporated under the Companies Act of Trinidad and Tobago, and therefore the final authority within the company lies with the board of directors, and that is fundamentally how we have operated. So there's been no opportunity for the Minister of Energy to be involved in decisions made by the company. Just another passing comment I would wish to make. Chairman and Senator, we take on board wholly the comments that are raised with respect to cooperation with this committee, and certainly one can testify by the voluminous documentation we have submitted to all the questions that have been raised by this committee from since day one, that Petrotrin is committed to providing all the work that is required to facilitate the activities of this committee, and certainly we look forward to the recommendations that emanate from the discussions that occur and from the deliberations of the committee. And that is our commitment. We remain committed to that, and we'll never deviate from that. We, however, will recognize that as a company incorporated under the Companies Act, there are a lot of things that are occasion to us that we must pay attention to under good corporate governance. And those things from time to time will pop up. We have heard the comments about where the filter lies and who determines that, and we understand that, and we appreciate that, and we intend to follow that as much as possible. We have responded, and I want to put on record that Petrotrin responded sufficiently and very adequately to the requests that were made at the last meeting for us to provide documentation that would have determined the deliberations of the board in this matter. We provided with full submissions in terms of another voluminous set of documents that the board considered at the time, and we indicated that some of the legal opinions that were given to us as company, and which are also part of other activities that are ongoing with respect to this matter that are not yet closed, in terms of other requests that are ongoing and are also before the court, that we felt under common legal privilege that we could not make those opinions available because there are still matters under consideration. That is a normal decision under the course of business for a company who is operating within this environment. With respect to all the other matters, we have answered sufficiently, and some will argue that we have answered more than abundantly with respect to what was required of us, and we continue to maintain that we continue to cooperate significantly with this committee, and our position has always been that we will cooperate with the entities in front of us, and we continue to do that. So I want to put for the record, as indeed others have spoken on the record, that Petrotrin remains committed to cooperating with the Parliament and with the standing committees, and there's nothing in our decision making that precludes us from doing that. We continue to operate as a legal entity within this country under the Companies Act, and where those obligations of us as a company preside, then we recognize our obligations under that, under due corporate governance, and we respond accordingly. And that has always been our position. So for the record, I just want to answer that. With respect to the other 6 questions, I want to ask our Corporate Secretary to respond to those that speaks to the legal issues.
Yeah, before your Corporate Secretary responds, Mr. Chairman, through you, could I ask Mr. President, are you prepared to reconsider your position, given what the chairman has said, that we are the filter, and we will treat as a responsible committee what is confidential, what could be made public? Or are you sticking to your guns that you have taken a decision not to supply this committee with its requests for those legal opinions, so that this committee, guided by what you would write to us, indicating what you consider to be highly confidential, and therefore you would want to have these matters discussed in camera, are you prepared to reconsider your position, or do you stand by your position that you wrote, and is now black and white, that you are not prepared at this time to supply us with those legal documents? I just want to get clarification on this matter, because it's very important for this committee's deliberation at the end of this hearing as to where we are going with Petrotrin. So that is why I'm asking you, if you want to reconsider the chairman's opening remarks in terms of the ability of this committee to treat with any documentation that may come before it, conscious of the sensitivity, the confidentiality, and the need, if it's necessary, to go and have a hearing in camera away from the public, because we are a responsible committee. So that is what I wanted to get clear from you, Mr. President.
Mr. Chairman, through you, again I respond. The whole construct of the Senator's questions seem to suggest that we are at odds with what you have articulated. And I want to again go on record as saying that Petrotrin remains committed to cooperate fully with this entity and other such entities as we stand before you. In that regard, we are well aware that we have articulated a position in our response to the committee in terms of the questions. We are also aware that given our governance structure, our board can, if so required, choose to waive privilege if it so desires, and it's so mandated to do, and so considered in its opinion as the right thing to do. And under such considerations, we are certainly willing, if the privilege is raised, and if we are guaranteed the SU of in-camera sessions, to consider anything that is before us. And that is where we are. I don't think it's a reconsideration, it's simply a clarification of our roles and understanding where we stand with the issue of corporate governance as an entity in Trinidad and Tobago. However, let me just further suggest to you that when we hear the clarifications coming from our senior manager, law and land management, I think it will put in better perspective the position we are articulating now in terms of being able to willing to waive legal privilege if so required of our board to deal with the issues that are in front of us.
Permit the chairman to just interject here for Mr. President. I want to thank you for your forthright response. This is a matter that has troubled the committee. The committee is happy to hear that the company recognizes that there's an issue that needs to be treated with. And I would agree for you, and I would say that on the record, the submissions received by Petrotrin have far and away, they've been fully responsive to the vast majority of questions. There's no question about that. So I want to confirm your position on that, so that let there be no doubt about that. But the one concern the committee has is that there were documents that in a letter you wrote in your submissions, that this is a document that you relied upon to make the decision. That document was not submitted. So that I understand you may have sent a whole folder with all of the legal proceedings, but the documents that the board relied upon to make its decision was not submitted. In the absence of that, the committee has a challenge, because there's no way the committee could understand the reasoning behind the board making the decision if the documents that the board used wasn't supplied. So I look forward to a reconsideration, a rethinking, a relaxation of whatever needs to be relaxed, to allow the committee, because for all you know, and for all the members of the viewing public who know, the committee may look at the documentation and in its report may indicate that Petrotrin, based on the information provided, has acted properly, and that everything is full and above board. In the absence of the information, the committee is hamstrung in making a decision. So this is the tension that we're experiencing, and I am happy to hear from you, Mr. President, that there will be some movement in the matter. I give back the...
Thank you, Mr. Chairman. Just before she continues, and again, we are very encouraged by your acknowledgement of our support. I think I just want to draw to your attention, though, that on the last occasion, it was on the direction of the chair that said we are required to disclose documentation subject to disclosure. And that is the premise under which we operated. So as far as we're concerned, we're operating within the ambits of the committee. But I'll ask the legal manager to get into the details.
Honorable Chairman, if I may continue on that issue, in respect of the legal professional privilege, I just wanted to clarify that it was not merely, Petrotrin was not merely looking at considering lifting the legal professional privilege, but Petrotrin, in these documents, you would see that Petrotrin is a party to international arbitrations. You have the ICC body and the London Court of International Arbitration, by which Petrotrin is obliged to maintain confidentiality. The witness statements that were given, that were relied upon in the opinions, those witness statements formed part of the records of these arbitrations. And it would be very difficult for Petrotrin to breach its obligations with an international body and give those documents. And it was for that reason we needed to have further deliberations. And if I may add, if those documents were delivered without more, it would be difficult for us to obtain witnesses and even indeed to appear before international bodies where you actually have confidentiality obligations. It has far-reaching consequences for the state of Trinidad and Tobago, where we appear before international bodies and we breach our obligations. So we just wanted to put that on record before this honorable committee, that in fact, that and apart from the lifting of legal professional privilege, that was also a major consideration for Petrotrin. And Petrotrin is obliged to act responsibly in accordance with the Companies Act of Trinidad and Tobago. If I may now turn to the questions that were raised. The first was any reason given for Varun Debedine wanting to withdraw from this matter? Before I answer on that, I would like to direct the this committee, to the where on March 1st, 2016, Mr. Debedine withdrew his application before the court. And in fact, our in-house counsel, Petrotrin Sharon Morris Cummings, came on record as instructing counsel. Perhaps it may be helpful to put in context, and when I do that, in so doing, I will be answering some of the questions that the Honorable Senator raised. Petrotrin in 2011, Petrotrin's then board resolved and agreed that the Office of the Attorney General will take conduct of this matter, that is the Malcolm Jones litigation. At that point in time, those directors, and I believe that's one of your questions, those directors were Lindsay Gillett, Aleem Hussain, Charles Baisden, Peter Burke, Carl Hector, Peter Inglefield, Kemran Joku, Rashad Khan, Rudranath Maharaj, Anil Ram, and Krishnadath Ramuta. And by taking conduct of the matter, the Office of the Attorney General assumed full conduct. It was the Office of the Attorney General that engaged Varun Debedine. Now, essentially, I would like to just stop a moment and just compare to what happens in-house. In-house, Petrotrin's legal department has in-house management of all litigation, arbitrations, etc., that actually occur. In fact, in my capacity as General Counsel for Petrotrin, I have had internal conduct of both arbitrations in respect of the GTL matter and also the SDNY litigation, which is the Southern District of New York litigation, which started in the Federal District Court in the U.S. In those matters, Petrotrin in-house would actually meet with witnesses. We would take proofs, which is statements from witnesses. We would actually revise pleadings. We would review all documents that were provided or that were drafted by New York counsel. So it's therefore we take a very active part. It's managing the litigation portfolio. However, in respect of Malcolm Jones' matter, it was the Office of the Attorney General that hired counsel in this matter. Petrotrin's legal department had no interaction with the Office of the Attorney General in the handling of the Malcolm Jones' matter. The first interaction or communication that we had from counsel was in July 2015, when Varun Debedine, I believe, wrote us asking for documents which were the witness statements and the tribunal awards in both arbitrations, because Malcolm Jones's attorneys had made a request, an application for disclosure of those documents. Now, because there's legal professional privilege, those attorneys are on record for Petrotrin. We supplied those documents to counsel. Those documents were reviewed, and we next heard from counsel, I believe, sometime in November or December, at which point in time he said the documents, an order was made for disclosure, and that Petrotrin was now required to identify who would be the witnesses in this matter. Now, that was difficult for us because we were unable to file our witness statements. Petrotrin had never been involved in this matter. We did not even know what were the claims before the court. we requested those documentation from Varun Debedine, and I said to him quite clearly that we needed to get those documents in order to identify who those witnesses are. In response, Mr. Debedine claimed privilege, and he said that he had been engaged by the Office of the Attorney General and he could not give those documents to Petrotrin. I reminded, in my capacity as Senior Manager, Law and Land Management, I reminded Mr. Debedine that he is on record for Petrotrin and he cannot claim privilege against his client. At that point in time, we were really between a rock and a hard place, to put it, because we were unable to file our witness statements. We did not know who the witnesses were. In an effort to meet the obligations and not to wait the court's time, I contacted the Attorney General's office, seeing that counsel on record was refusing to respond to our requests. I contacted the Office of the Attorney General and asked whether he can intervene. At that point in time, we had an all-counsel meeting. At that all-counsel meeting, Mr. Debedine agreed to withdraw his application to come off that matter. In his affidavit, and we have provided all those documents to you, Mr. Debedine claimed that he was unable to receive instructions from us. Our counsel, Sharon Morris Cummings, went on record and did file an affidavit in which we said we were unable to provide information because we were not getting any of the documentation from counsel. And therefore, we were really hamstrung in providing those witness statements, identifying those witness statements. Now, as I've said before, in dealing with the litigation and the two arbitrations, I have said that in-house counsel would actually meet with witnesses. We'll take proofs of statement. So had we been involved, we would have known who those witnesses were. And as it was, we were really not in a position to identify the witnesses. And the trial was imminent. Trial was in February, I believe. And Mr. Debedine eventually requested an adjournment, an extension of time to file those witness statements in court. I don't know if that sufficiently answers your question.
If you permit me,
Yes.
Ms. Adar Singh, I just want to be clear. What you're saying is that this action began outside of Petrotrin's ambit.
It began outside of the legal department, Petrotrin's legal department's conduct.
And that the first contact with Petrotrin on this was in July 2015.
July 2015, when we were written to provide the documentation in respect of the arbitrations.
And the counsel on record, Varun Debedine, who's supposedly on Petrotrin's side, was not able to provide the information that you requested because he's your counsel on record.
Yes.
Thank you. I just wanted to get it clear in my mind to make sure I'm following.
He did eventually provide documents to the Attorney General's office. He provided a dossier, and I would say that he did provide us with a link when we kept pressing him. Yeah. But that link, those documents were illegible. We really did not have the documents.
Okay, thank you. Continue.
Okay, you had asked the second question, who had compromised, the composition of the board, and I have given that.
The alternate chairman.
The alternate. Sorry?
Yeah, I know you're continuing.
Okay. The alternate chairman at the meeting, in accordance with the bylaws of Petrotrin, the company, an alternate chairman was appointed, and that was Leonard Prescott. Okay, the cost lost, I am unable to give you an indication of the fees. I will have to get that information and supply it. The rationale, could you repeat that question, please?
No, I asked what was the rationale used for determining the decision to discontinue the matter?
Okay, as indicated at the last session of this honorable committee, the attorney, the Queen's counsel in the matter, who had given the initial opinion, he, upon looking at the witness statements and the decisions in both arbitrations, gave a further opinion, and we have supplied the decision of the board to this honorable committee, in which the opinion was, in essence, that having looked at what had transpired in the arbitrations, it was really not a case. It did not seem to be a case of negligence. I wanted to ask, to add further, we have supplied the arbitral award of both arbitrations, the ICC and the LCIA arbitrations. And the reason that we can do that is when we were in the process of enforcing the judgments in the Southern District of New York courts, we filed those awards. Those awards were made available to the Honorable Committee, and the awards really speak to the evidence that were led, and the awards are public documents. The awards talk of the evidence that was led, it talks of the pleadings, and it has the findings. Those awards were what were looked at along with the witness statements.
So, Mr. Chairman, if you could provide this committee with the names and positions of the other persons who constituted this particular meeting that Mr. Leonard chaired. Ask that question.
The persons, yes, it was the rest of the board members, save and except the chairman of the board, Andrew Jupiter.
Okay, thank you. I now give the floor to Senator Bash. Senator Bash, you have the floor.
Thank you, Mr. Chairman. Pleasant good morning to the Petrotrin team and representatives from the ministry. Given the dismal outlook for crude and product prices, as well as Petrotrin's current challenging financial situation, it would seem as though cash for capital projects in the coming years would be difficult to source. As you have rightly identified, increasing production and reserves is a key strategic imperative. Has any serious consideration been given towards attracting increased private capital to E&P operations? Specifically, can you provide a response to the following? There are areas of land that have remained idle for several years. When was the last time that a company did an acreage rationalization plan? How many idle wells are there onshore that can be brought on production by a low-cost operator?
Through you, Mr. Chairman, and to the Honorable Committee member. Your point is certainly well noted, and as of November 2015, when we looked at our acreage portfolio, we decided that it is absolutely necessary to do just what you have indicated. We have quite a number, we have a large acreage indeed, and I have the numbers here in terms of the overall acreage. Just permit me if I just get the actual number, but it's in excess of a million acres of acreage, both land and offshore. And certainly we are reviewing our position with respect to the overall asset management from a reservoir standpoint in particular, because as you're aware, we have quite a number of private partnerships existing in terms of lease outs, farm outs, incremental production sharing contracts, and joint ventures. And we are of the belief that from a reservoir management standpoint, that isn't being done as well as it should be, because we know from a volumetric standpoint there are quite a number of barrels in place, and certainly we have not been able to have that recovery that we so desire. There are a lot of idle wells, as you indicated, and there's a lot of idle space to play in. And we believe if we do a proper study in terms of our asset from various standpoints, which will be from an economic standpoint, from a reserve standpoint, and of course from a technology access standpoint, there's much benefit to be derived from allowing different partners with different skills to play in that asset basin. But first of all, we really have to do that study, that evaluation, and we have embarked on that. And from there, we will be deciding the strategy in terms of how we go forward, because certainly from it has to be done in economic profile and outlook. And we know that there are operators that are able to bring, as I said, capital, technology to the table, especially in a brownfield, stripper type field operation that we have.
Thank you very much. Are there any other innovative programs being considered for attracting private capital to the E&P operations? My understanding is that Petrotrin team visited Colombia within the last 2 years to gain insights into what the state company, that's Ecopetrol, I think, did to increase production and reserves via private capital. Can we have a sight of a copy of the team's report and specifically the recommendations that should be adopted by Petrotrin?
Yes, certainly. Through you, Mr. Chairman, we could definitely provide a report on that particular visit. And yes, indeed, a team did visit Ecopetrol, and simply because, as we all know, Colombia is one of those countries that have been able to grow reserves and production significantly in a short space of time. And there were quite a number of reforms that were done, including private capital and, of course, their own type operations that we were able to use. So this project, as it were, was called the Mature Field Rejuvenation, and it had to do with bringing private capital, and the payment structure would have been on incremental oil added, and of course there was ownership back to us in terms of operating the field. Since then, the oil prices have significantly declined, and we have been in concert and conversation with these companies, and quite a number of those contracts are being renegotiated at this time because, again, where the oil price is. So we have sort of put a little hold on it in terms of going forward with that particular approach and that model. We believe, though, that there's space for private capital to play along with technology, but in terms of that, the specifics of that model we are revisiting, and certainly we are going forward re-looking at that. Notwithstanding that, we are also looking at our internal own operations in terms of streamlining them to make sure they're efficient. So we want to have a balanced playing field and a very robust, sustainable playing field moving forward. Those are the recommendations. We have been in conversation again with some of the other major players that have been involved in those types of contracts, and we again learning from them, and we are seeking to do just that as we move forward, because we certainly believe that there's room for private capital, there's room for our own capital in terms of developing reserves and production based on the risks that are involved.
Thank you. I do look forward to your report. My other question to you is, what is the status of the Jubilee Field production? There was much fanfare and celebration when this was announced in 2012, and promises of significant new production in 3 years. It is now 4 years, and?
Okay, yes, Jubilee is a field that that's what we recorded as being discovered just a couple years ago, and what was important about that discovery, it was in an area of heavy oil, traditional heavy oil production, and there was a light oil discovery. Further to that, there has been significant work in terms of understanding the extent of this light oil reservoir, and in addition, understanding the entire business of heavy oil production. Since that, we have done some technical work subsurface, and there's a need for quite a lot of appraisal drilling to be done, because as you would appreciate, the geology is quite complex in those areas, and some preliminary work that has been done would have indicated that this is quite faulted. So even that light oil reservoir, there are some questions that we still have to ask ourselves in terms of the extent and the volumes that we could produce from a very economic standpoint. We are in no means a technology leader in terms of heavy oil production, and as such, we believe that we need to find a suitable partner from a capital and from a technology standpoint to be able to provide the way forward in terms of how we develop the field. I think we have to also understand that from a refinery consumption standpoint, we have to understand clearly what the diet of our refinery is to be able to monetize that and bring that to the fore in an economic way. So the work is being done, notwithstanding from a portfolio standpoint and from available capital. There's some changes in terms of focus because we have some projects that are sort of imminent in terms of delivery for increased production, but it's in no way, as we indicated earlier on, from an overall asset management from the land and from the offshore acreage. We have to relook at our strategies in that regard and make the right decisions. But what will drive the Jubilee in particular is, of course, capital and technology to be able to recover the heavy oil reserves in that area.
Just allow me, Senator. I have been asked to acknowledge the presence of Mr. Daniel James, who is the clerk of the House of the Assembly of Dominica, who is observing today's proceedings. Mr. James is the clerk of the House, and he's on an attachment to our Parliament, and he's observing the processes of our Parliament. So I'd like to acknowledge again Mr. Daniel James, the clerk of the House of the Assembly of Dominica. Thank you for joining us, and you may proceed, Senator.
So we are moving forward, Mr. Vice President. We are moving forward with the project.
I would say we are relooking again the portfolio. It is an asset that's available for exploitation of reserves, but in terms of a priority, we are looking at some other areas in the field that we have done a lot more work in terms of subsurface modeling, field development, and at this time, at this price, going after those types of reserves could be very challenging from an initial investment standpoint. Certainly from the technologies out there that we want to bring it to bear, and more than likely, as I said, as we look at the portfolio from a risk for capital, technology, etc., a suitable partner will be needed to go after those reserves, bearing in mind fully understanding the diet of the refinery also.
Okay, thank you very much.
Okay, welcome.
Thank you, Mr. Chairman. Mr. Chairman, I'd like to direct these two questions along the lines of my colleague, Senator Mark. First of all, given this debacle that we are now looking at and the withdrawal of the lawsuit against Mr. Jones, are we yet to know of any more contingent liabilities that we have not been yet told? Or are there any unforeseen or unknown to us at this point in time that we need to prepare ourselves for? Secondly, from the experience of the past and reading about this company, its predecessor, persons have been known to be prosecuted or persecuted for much less amounts of money in terms of errors that were made, deliberately or otherwise. To what extent this $2 billion debacle that we are looking at here would have impacted and affected the continued viability of Petrotrin since the decision was made contrary to good advice by very many? It appears that it was a single unilateral decision. That is what the public domain is being treated to. So if you could address those two questions, please.
In respect of your first question, you ask whether there was any contingent liability, and by that I interpret that meaning any other legal matters. That is another. We have some live issues at the moment, ongoing matters, which Petrotrin's board will also need to consider in lifting of whether it wishes to lift legal professional privilege. Because when you lift legal professional privilege, you would be exposed to all other actions in respect of this matter arising from the same facts as they were. His second question, I believe, is more for the President to answer.
So, Chairman, through you, indeed, we have had a number of issues within Petrotrin, and I think it's clear to everyone that there are a number of legacy issues within Petrotrin, and we are at the point of refocusing the company on the business model I articulated at the start of the presentation, and we want to focus on our business and attempt to carry the company forward. There are issues that need to be properly dealt with and be examined, and we continue to examine the company where those issues pop up, and they are not. I want to suggest to you that the GTL plant is not the only debacle within Petrotrin. There are some of more recent vintage. For instance, the way our Southwest Soldado development was handled, and all of those things are being examined, and where they offer us the opportunity to seek redress for what we consider to be errant decisions, we will do that. And that's fundamentally the approach we're taking. We are being very open-minded. We are looking at what has happened in the past and examining the business, but we are keeping our eyes very focused on our business model going forward to ensure the sustainability and survival of the entity that is Petrotrin in the path going forward. So we have not dropped the ball on either of those two objectives.
Mr. Chairman and the President, I didn't mean to be facetious in terms of the importance of all the matters, but I was really getting to the point where I was asking to what extent this decision that was made in 2007 would have affected immediately thereafter the financial viability of the organization, even to the extent today it is in a difficult position to reposition itself, even within the context of the business model.
So, Chairman, again, it is difficult for me to leave the claim only on GTL, and I think it's important to understand that we detailed at the last occasion a significant cost impact as a result of the GTL project that we continue to treat with as we attempt to bring some closure to that activity that predated as 2005 or even before that when the decision was made. There have been a lot of things that have happened subsequent to that continues to create challenges for the organization. We've had the GOP project, the ULSD project, we've had the Southwest Soldado development. There are a number of issues that continue to be dealt with this company. Could we say that that particular one has encumbered the company? Our view is that all of them, acting in concert over the last few years, have brought us to a place where we feel challenged, and we think we need to now focus significantly on our efforts going forward. And I didn't interpret your comment to be facetious in any way. I'm simply just reinforcing the fact that we are keeping our eyes on everything. We are keeping our eyes on running the organization and keeping the focus on that. And as we continue to examine the operations of the company, where there are issues that have reared their heads and things have popped up that require us to address, we will be addressing those things. But we are not operating, to use our local parlance, vai-ki-vai. We are trying to be very deliberate, and we're reviewing our business operations, and where we have unearthed, through whether it is formal audits or through our own investigations, actions and decisions that we think are inimical to the survival of the company, we will take action on those items, and some of them are actually under consideration at this time.
Thank you, Mr. Chairman. Just a final one. How will you rate the WGTL project in terms of the magnitude of this misinvestment compared to the others in the history of Petrotrin?
Chairman, I suggest that is an unfair question to pose to us, right? This is a serious matter. I mean, we have established that in uncertain terms. We have established in the past considerations and the submissions that we have made that this has cost us a lot of funds. But this is a matter that it's on its tail end, if you will, in terms of us trying to bring some closure to it. There are other matters in front of us that are very significant. Do you ask me, do I rate those as significant? They're extremely significant because they occupy us now and they impair us now. In the case of GTL, we've ring-fenced that activity to some extent. We have taken a lot of actions over the last few years, and we have come to a point now where we are trying to bring some closure to that activity. As a matter of fact, we kind of want to see what happens in the future because we still want to be able to protect our interests going forward. But there are other items that are now in front of us that I consider to be much more demanding and much more risk, if you will, to the vulnerability of the company and to the survival of the company. And that is where we have focused our attention. Doesn't mean that we are not on the focus with respect to GTL, because we're not dropping the ball on anything. But we're just simply saying that there are some that are a lot more current, unfortunately, that comes after that requires as much attention as we've been doing with GTL.
Morning, everyone. I'd just like to follow up on that issue raised by Honorable Member Karim. You keep saying that there are other issues that are more important, and one in particular you mentioned in the current scenario was the Soldado Southwest development. Could you elaborate on that? I mean, what were some of the issues involved? And overall, what are some of the current challenges that you are alluding to that we haven't elaborated on to the extent of the GTL issue?
All right. This one, Mr. Chairman, I think it is fair to say that this one, there are indeed a significant amount of sub-judice items with respect to this one. But nonetheless, the Southwest Soldado development, and the Senator asked about Jubilee a while ago, but the Southwest Soldado development is a development that we had targeted as a company to allow us to be able to make significant improvements to our equity production within Petrotrin. It's a project that dates back to maybe as far back as 2005 or even before that, as maybe the 1990s, as a matter of fact, if you go back as far enough. But the recent issues that have occurred with respect to the execution of that project, that, as you know, are very public and were involved in the public domain in terms of newspaper articles, etc. Those items are now being investigated, and some of those items are actually before the legal authorities, and therefore become sub judice to some extent. So I really don't want to get into too much of details of what we're doing now. But that is a project that has certainly challenged us in terms of its execution and put significant strain upon the operations of the company as we try to bring resolution to it to go forward.
Thank you very much for your responses, Mr. President. I have a couple of easy questions now, if you permit it, Chair. I have been advised, in your submission, you indicated that the annual administrative reports for the period 2008 to 2014 have been submitted, but we don't seem to have them here. So could you, perhaps the Ministry of Energy could assist also in responding? You've submitted it as opposed to the Ministry of Energy. Would the Permanent Secretary, Ministry of Energy, be able to help with where's the status of those in terms of their lane in the Parliament?
Yes, thank you, Chair. The subject of another meeting that we had in this place regarding the submission of annual reports, we followed up on that matter, and in fact, Petrotrin is accurate in terms of their submission of the documentation. As you know, the documents then have to go through the process of going to the cabinet and laying in the House. We are in that process right now with respect to the reports submitted by Petrotrin and other state entities. So I'm just confirming the fact that they have submitted all the reports that they
Thank you very much, Mr. President. Mr. Permanent Secretary, you know that is an issue that is engaging the committee also, and we're happy to hear that Petrotrin is virtually up to date with their submissions. I have another easy question, Mr. President. I want to refer to a report or a comment by the previous Minister of Energy in the Hansard of the Parliament in 2014, where he was responding to questions regarding deficiencies in Petrotrin's operations identified by the Ministry of Energy. And I want to quote from the Hansard of 2nd of April 2014, where the then Minister of Energy advised that in the year 2011, deficiencies brought forward from 2010 were 966, and new deficiencies that were observed by the Ministry in that year were 2,085. In 2011, 1,193 were brought forward and 1,858. And so it goes, so that we're in a situation where it seems that the Ministry of Energy's inspection unit is going out and identifying deficiencies, and Petrotrin is struggling to respond fully to the deficiencies regarding. I only have data up to 2013, where it's saying that they have 1,923 outstanding from the previous year. So that it might sound like a big number, and I have some experience with this, but I think that it's a number that is out there, that the company is having some operational issues regarding responding to the ministry's requests. And part of the response to that was that there was this facilities audit plan along those lines. I would like to get an update on where that is, so that we can understand the company's ability to rectify the deficiencies identified by the Ministry of Energy's Petroleum Inspectorate Unit.
Thank you, Mr. Chairman. Maybe it's useful that you raise that, because when we are asked what is our greatest pain, it's not so much the past things, but the ones that are in front of us. Petrotrin has a serious asset integrity challenge. A lot of it from legacy issues, as you would appreciate, both in our refining as well as in our exploration and production division, and we've had a number of incidents in the past related to that. We are continuing to review the audit responses, if you will, that come from various ministries, including Ministry of Energy, as well as from the Occupational Health and Safety Authority, as well as others like the EMA, etc. With respect to the specific item you have raised about the facilities audit, that facilities audit was initiated by the Ministry of Energy, and they had used DNV as the provider for a number of state enterprises. A presentation on the results of that was made just a month ago, and we attended and heard the various submissions, if you will, from DNV with respect to their assessment of the state of asset integrity throughout the industry, and including in many state enterprises, including Petrotrin. We have deliberated on those findings, if you will, and we are at the point where we will be pursuing a separate audience with DNV to specifically review the Petrotrin results, because their mandate then was to do the entire state sector and the companies in Trinidad and Tobago, and we have decided that we will pursue them to have a download, if you will, of the information related to Petrotrin specifically and the areas that we can focus on improvement. Notwithstanding that, we continue with our own asset integrity improvement efforts. Of course, there is a significant need for investment in that area, and our approach with respect to capital, financing, etc., is completely tied to our ability to deal with some of those issues that are in front of us.
Thank you very much, Mr. President. The chairman has one additional question at this point in time, and it has to do with the release of FCCU catalysts, and perhaps the record is fluidic catalytic converting unit. There was an incident in November, I believe, of last year, where there was an upset condition at the unit, and that it ended up with white powdery substance being deposited in Marbella. And that in the response to this, the Honorable Minister of Energy, the current one, responded in the Parliament that Petrotrin has indicated that all affected persons have been documented and a whole series of actions have been taken. My question is around the composition of what was emitted. I'm not a chemical engineer, so I'm not going to claim any chemical engineering degree. I leave that for the Permanent Secretary of the Ministry of Energy. But FCU catalysts contain several chemicals that are deleterious to human health. One of those is something called vanadium. And to the extent that we recognize that this incident has happened, I would like to understand what remedial action, what testing was done, because I've probably done too much reading. And I've seen where there's been other FCCU upsets in other places. And one of the concerns is the extent to which residents have been exposed to vanadium and other chemicals that are deleterious to health. Vanadium is a naturally occurring item, but prolonged or extreme exposure can have long-term health effects. So I'd like to understand from the company whether or not when it completed its work on this exercise, was there testing, were individuals who were affected, was there testing done for vanadium and other chemicals? And in terms of the cleanup work, because vanadium ended up on all over the place, what entail in the cleanup work? If vanadium gets into the soil, whatever comes out of the soil is going to be impregnated with it. So that my question is on two levels. Did Petrotrin indicate as independent lab analysis of what was emitted? And then two, in terms of the potential effects on people's health, what were the actions taken by Petrotrin to make sure that the residents in this fence line community were properly protected?
Chairman, due to the nature of the event, the majority of the material emitted was more of a fresh catalyst variety rather than the normal circulating inventory. Part of the operations at Petrotrin are that we hydrotreat the FCC feed, which means there is a significant reduction in the vanadium content of the oil that goes to our unit compared to a unit that doesn't hydrotreat the feed. So the levels of vanadium in the catalyst emitted were, in the context of the refining industry, relatively low. Throughout the cleanup, we invited all of those individuals who felt that they may have suffered ill effects to present themselves, and we treated with those accordingly. As you stated, I think, Mr. Chairman, essentially vanadium is not an acute poison, it's a chronic poison. And we are comfortable that the community of Marabella hasn't suffered any chronic ill effects.
Thank you very much. Senator Mark, you wanted my attention?
Thank you. Thank you, Mr. Chairman. I have some questions dealing with the post-receivership costs. When does the company, that's Petrotrin, intend to complete its advancement of funds to the receiver? I think is it Price Waterhouse Coopers? Who is the receiver of the WGTL? Because we got some figures the last time, Mr. President. I do not know if this is unprecedented, but it was some $55 million and climbing. I think that is the figure I recall, if my memory does not fail me. But that is what the figure I recall. I also would like you to confirm when and how the breach in contract was detected and what was the immediate action taken in this issue of the receivership or the receiver. I also would like you to bring this committee up to speed with the status of the sale of the GTL plant assets and what is the cost at which a company is proposing to sell these assets at. I know you had given us some figure when you had first come, but between then and now, things may have changed and you may want to apprise us. And could you confirm again who is the proposed buyer? And were there any other proposed buyers? Or are we still stuck with one buyer? And was the proposal for the sale of assets advertised and tendered so that the company could maximize on the sale of these assets, obtain value for money, and salvage some funds? Is the proposed deal with the proposed buyer, Nikwan, the best option for treating with the disposal of the assets? And are there any other options to which Petrotrin has given consideration? And could you explain in this regard? These are some of the clarification I would like to have on these matters. Mr. Chairman, through you.
Mr. Chairman, thank you. Let me just deal with the larger question of post-receiver cost, if you will. And again, context is important, and we spent a lot of time at the last session detailing, if you will, the sequence of events with respect to this facility. But more importantly, we identified that in 2009, the activity for construction of that plant and completion of the facility went into receivership. Petrotrin, as the debenture holder, who would have then acquired the loan, would have placed the facility into receivership. The receiver, PricewaterhouseCoopers, through Mr. Hackett, became the fully autonomous person with respect to trying to complete the facility in the first instance. We need to remember that, because when we talk about post-receivership cost, a significant amount of the cost, and we detail that in the recent submission we just gave, which is another example of the completeness of our submissions. I couldn't help that, Mr. Chairman. But in that submission, we indicated, if you looked at the first few years, 2009 and 10, and even into 11, a lot of the cost was related to trying to complete the construction of the facility. It was at the point where it became evident that completing the construction of the facility became futile, that the decision was then made to attempt to sell the facility. And the receiver's mandate as receiver would have then moved into the point of trying to sell the facility. The receiver executed his process with respect to advertising the facility, and it was tendered, and the receiver would have received bids, and the receiver would have evaluated those bids and made recommendations to Petrotrin with respect to the proposed purchase. And that was to Nikwan Energy, which is where we are today. Again, as I recapped at the last meeting, the board had given conditional approval for the sale of the facility to Nikwan Energy, as you have identified in your subsequent question thereafter. And the idea is we are at the point now where we are attempting with the receiver to bring closure to that sale. There are a number of procedural items that are required for us to sign off on that documentation, and also there are a number of procedural items and agreements that are required to be enacted, if you will, and executed before the closing of the deal is finalized, and that process is where we are at this point in time.
Time frame, Mr. President, as to when you believe closure would be brought to be on this particular project in terms of getting a sale, finalizing whatever final costs the project would be sold at, or the plant. Do we have any specific timeline? For example, are we saying that by the end of December of 2016, that particular project, whatever state it is in, would be disposed of? And if you have to get, as you have indicated earlier, 35 million US with 10 million coming in cash and 25 million coming in preferential, I think it's preferential shares, if my memory doesn't fail me. Do you anticipate that by the end of this year that would be concluded?
Thank you, Mr. Chairman. Again, let me just state that we are working with the receiver on this matter. This matter, there are many aspects to it, if you will, in order to bring final closure. There is the aspect of the actual sign-off of the sale and purchase agreement, but the actual closure of the transaction, there are a number of conditions, precedent, and prerequisites that are required to be completed. And the expectation, I think, within the documentation and the language is that it allows for at least 18 months to 2 years to allow for the closure of those matters, to finalize the closure of this deal. So that is what is ahead of us. We are at the point where we are working with the receiver and having conversations with him about bringing the first part of that activity, if you will, to trigger it, which is the sign of the sales and purchase agreement, which we expect to happen soon. And the receiver will really appraise us as his timeline with respect to that. We have detailed to him our expectations in terms of what is required according to the agreement to be put in place and what we understand to be the items for closure. And he is negotiating and liaising with the prospective purchaser. And our expectation is that thereafter, once we have signed, we will then be moving again under the guise of the receiver to bring closer to the transaction.
I also asked the President if he could provide in writing. Because remember, I think at the last hearing, you did indicate that no estimates were available for the number of contractors and employees that would have been impacted upon by reductions in your costs as you seek to become more efficient in your operations. Could you provide us in writing the number of contractors and employees who have been dismissed in the past 10 years? Is that too long for you? Or you would want to give us in the last 5 years? But I would say that if you could provide it in writing, you don't have to answer it immediately. If you can't, you wouldn't have that information. So could you provide, through the chair, in writing, the number of contractors and employees who have been dismissed in the past 10 years for this Joint Select Committee?
Thank you very much. MP Leons, you have the floor.
Chairman, if I could.
Mr. You may be uncertain as to the request.
Yes.
Yes. So that the committee will clean it up and the secretary will communicate with you in writing. So don't panic.
Thank you very much, sir.
Yeah.
I hate to be accused of the same thing again. So.
Well, I appreciate that. And remember, the committees we kind of sitting opposite each other, but we're on the same side. Because we're on the side of Trinidad and Tobago, Mr. President.
Thank you.
At the end of the day, this is a cooperative effort between the committee and the company to seek the best interests of the people of Trinidad and Tobago.
Agreed.
So I appreciate that we will make sure that it is crystal clear, and you will receive it in a way in which it allows for easy response.
Thank you. Thank you, Mr. Chair.
No problem. Mr. MP Leons, you have the floor.
Thank you so much, Chair. I just want to make a general comment, and maybe out of the comment will come a question. Now, we are here because we understand how critical the operations of Petrotrin is to the country and the economic performance of the country. And something you said earlier, it troubles me, in that the issues, the questions we were asking, you said that you all were coming to a close. But more importantly, there are several other issues that has come up that is, in your view, paramount. The country is anxious to know these issues that are coming up. These deals that have failed, who is accountable for it and what is going to happen? But more importantly, following up on Member Mark's comment in terms of a timeline, these new issues that arise, how long would it take for us to get a real handle on the full problems that Petrotrin is in, basically? Because I'm not sure if you understand where I'm getting at. Things are coming up in parts. When we are understanding, I understand now. I applaud the commitment that your team have in terms of trying to close these areas off and bring a resolution and move forward in terms of improving the operation. But it's almost as though there isn't a sense of what is the real scope and size of the issues that the entity has. Can you share some light on that, please?
Thank you, Mr. Chairman. I go back to my first statement about Petrotrin being an integrated oil company. So from where we sit as a leadership team, we have crystallized our activities, if you will, around a few key areas that, if you will, we can summarize the challenges that we face. The first is, of course, our safety performance. We are not happy with our safety performance. We think that we have had a number of issues in the past. We've had fatalities. We've had a significant number of lost time injuries. We have a frequency rate that suggests that we should be expecting at least 20-something persons being injured every year. We think that that is unacceptable for this business. We think that that is going to affect our ability to run the company in the future. And so we're very, very focused on improving our safety performance, and we have identified that we need to push our beyond compliance culture within the company and put mechanisms in place to make that happen. So there's a focus with respect to that. We've identified as well that our asset integrity is in a poor state, and that the company is basically operating in an environment where, except for some of the plants that have been recently built in the refinery, we are running with some very old infrastructure and old facilities, and we are challenged with our asset integrity, and we have no assurance around asset integrity. Each day we are concerned about what is in front of us, and we're concerned whether or not we'll hear that something has leaked or something has caused a failure or a rupture or damage. And so asset integrity is a big issue for us. It's a huge issue when we're working on establishing our asset integrity management systems and our procedures, but at the end of the day, we are also documenting and detailing, if you will, our cost expectations with respect to the expenditure related to that, and it is huge, it is significant. There's certainly more than $5 billion to get us to a point where we can make the requirements to get us up to scratch. It's also an issue that demands of us how we manage the entity, because to deal with some of the asset integrity issues, we have to also recognize that we have operating facilities in play, but we still have to deal with the asset integrity issues. And then we have to figure out how to keep the business going. So I've talked about two so far, right? The third for us is to run as a very profitable business, because at the end of the day, that is what we are here for, and we intend to bring value back to the organization. So for us, being able to recognize good margins, and the senator in her early questions prefaced it by the fact that we're in a period where the oil prices are lower for longer, and our refinery margins are also lower, which is something that we don't seem to appreciate, that we are getting hit with a double whammy. So while we're experiencing low crude prices, we're also experiencing depressed refinery margins, which is affecting the revenue generation capability of the company. But interestingly, and I want to pay full commendations to the refinery team. We are at a point today where refinery is doing far better than we had ever experienced in a long time. And as recent as this morning, the refinery is doing 165,000 barrels per day. For the month of March, we produced as much as 153,000 barrels per day of refined products, and we were able to sell 154,000 barrels per day of refined products. So that is for us a bright spot. It is suggesting to us that with diligence and hard work and really focus on the business, we can turn the business into a profitable entity. So we're doing that. But then we have a fourth challenge in front of us, and that is our people and our competence. And as we look throughout the organization, we are seeing that we have significant challenges with respect to the adequacy or the competence within the company. And we are seeing leaks, and we are seeing challenges in key areas that are critical for us as a business, both in our refining area and as well as our exploration and production area. We're also looking ahead and seeing that just based on the normal attrition that occurs within the organization, we'll continue to lose some of those competencies. So for us, being able to deal with that in terms of succession planning, which apparently was never done for the last few years, and not focus on in a real way, in our view, in a way to give us the results where today we feel impaired and concerned about that. We are focusing our efforts on what we need to do to get the optimum organization going forward and what sort of competencies we need to build. And then we have also identified that we need to ensure that technology, you heard the VP, EP talk about if we have to go after certain land acreages and marine acreages to get the value out of them, we need to apply the appropriate technology. And so we've decided that we want a sort of holistic approach to how we deploy technology throughout the company. All that is our strategic focus, because that is what we think is going to keep the business sustainable. Along the way, we are faced with the challenges, as you have put it, of the initiatives that have been modeled, if you will, and corrupted with practices and behaviors that are less than honest and would have not conformed to what we expect to be good corporate governance. And we have to deal with that. And so we are also examining those issues simultaneously, and where they have, but they require due diligence. They require us to go in and examine appropriately and to get the right support in terms of audit reports, etc., and for us to take action. And so we are not being willing to just move off the cuff with respect to those things and speak out of turn. We've been doing our homework, and I want to assure you that we will treat with the issues where they show their heads with respect to poor performance and where we have seen activities that we consider to be less than in the best interest of the company in the past. We will bring that to the fore, and we will treat with those issues, because we are not dropping the ball on those things. We'll keep the business sustainable, but we'll also treat with the past performances that have been not what we like it to be. And that is the message we want to leave with the country and with entities like this. We are not here just to deal with a 2005 issue and to try to rectify issues. Some people think that we are only on the board, on the management to try to protect others from the past. That is not our objective. We have a business to run. Safety performance that is beyond compliance, asset integrity that we feel assured about, a profitable business enterprise, and the competent people to run the business with technology that is deployed appropriately to carry us forward. That is our focus. And we have been focusing our management team and our professionals and our stakeholders on trying to get us to that place. We've been meeting with all our stakeholders, including our unions, and talking about those issues, because for us it's extremely important to have people buy into the vision and to work with us. And it's going to take a while, because we are coming from a bad place. We are coming from a place where there have been a lot of neglect and degradation in the past, and where we focus on the business. And we really would need the space and the time to turn it around, because it's not going to happen overnight. And many times people have made interjections in Petrotrin in the past, almost with a desire, if you will, to flip it around in 6 months or so. And we have heard those stories. That will not happen, because this is a huge entity. It's an entity that spans, as you heard the chairman talk the last time, acreages throughout this country. And it's a huge and important entity of about $42 billion in assets that we really need to find the time and use due diligence and good corporate governance and good management practices to run it as a business and a company, and that's our focus.
MP Karim, you have the floor.
Thank you, Mr. Chairman. Mr. President, throughout your answers this morning, you have made reference to your improved business model, which you seek to accomplish. And more recently, you just spoke about 5 key pillars for attention. You did remind us as well that as of this morning, you're at 165,000 barrels per day. Can you tell us whether that is an increase in the local crude? Or can I ask it in the other way? What percentage of that 165 continues to be a local crude versus your imported crude? Secondly, and contingent with that, do you have any plans to increase your lease operator farm out program to so increase? It may have been asked in another way earlier on this morning. I have a few questions after this, subsequent to particularly with respect to item number 4, your people and competence I want to raise. But if you could address those two in the meantime. Thanks.
Thank you, Mr. Chairman. Our crude production, what we like to call our equity crude production, which really includes land, our joint venture partners, as well as our marine acreage, averages around 45,000 barrels per day. Or in some last month or so, it was more like around 43 or so. So that's kind of where our equity crude production comes from, and the rest we purchase as crude purchases to get our refinery throughput up. And that has been the traditional model of the refinery, even in the heady days when crude production was around 60,000 barrels or so. If you had to get full utilization of the refinery, which is now post all the many projects that have happened in terms of GOP, etc., we are now at the point where we can realize the true value of the refinery and the upgrades that took place and push our refinery performance where we like it to be. In terms of, what was the second question? Your second item? Yes, I think the vice chairman, the vice president, sorry, of ENP had already addressed that, and that we continue to review the acreage under utilization, and that is a process, and sometimes we need to remember that, because again, there is almost an intent, if you will, and a willingness to try to pull us back into the days of the flip-on decisions, and we've been very careful to establish processes and due diligence. So when we talk about how we increase our acreage and that sort of thing, we are going through a process with respect to that. We evaluate, we do the technical studies, and then we determine whether or not there's a recommendation we can make to our board with respect to how we treat that. And that process is ongoing and very active at this point in time.
Thank you. Mr. President, before I give the floor to Senator Mark, I have a quick question regarding the recent downgrade of government bonds and the downgrades to the government. Has that affected in any way the company's plans regarding its own bonds and the strategy that you outlined at the last meeting regarding perhaps looking at trying to extend the term of those bonds? Has the recent downgrades by Moody's affected anything to do with the company's strategy and how it manages the debt portfolio?
Well, it certainly continues to challenge us. One of the things we are always in the market, really our debt is around 3 areas, right? We have long-term debt in terms of the bonds, and we have short-term debt that is basically around working capital and trade financing. Obviously, the downgrades that have occurred with respect to both Moody's and S&P, and in some cases we are fortunate that S&P kept our rating as it was in the previous review that they did. If the rating agencies downgrade us, then we experience wider spreads when we go out on the market to borrow. It also has an issue to do with confidence by the lenders, and sometimes they are concerned about what is happening within the industry and within the country. And based on the level of government support, they determine how much they will advance us. So far, we've been having to have a number of very tough conversations with them, but certainly within the recent few weeks where we've had the rating numbers now out, and we have seen some different, I don't want to call it growth, but we've seen a different performance in the market, then we've found that we're able to still go to the lenders and get the required trade financing and working capital to carry us forward.
Senator Mark?
Yes. Thank you, Mr. Chair. Is it correct, Mr. President, that the employees of Petrotrin have, as part of their collective agreement with the company, a profit-sharing agreement based upon the profits declared by the company? And since the inception of the WGTL debacle, Petrotrin has declared losses on its books. And therefore, is it correct that as a result of this, the employees of Petrotrin were unable to benefit from their profit-sharing plan with the company? And what would you define or describe as the average loss to the employees as a result of Petrotrin's carrying this loss on their books? This is the first leg of a two-part question I want to put to the President. As I said, you may not have this available to you at this time, but you can probably give us a brief summary, and then you can probably place everything in writing. To the Ms. Radhika Maraj Adhar Singh, you did indicate to this committee earlier that the Attorney General's office had complete conduct of this Petrotrin, this matter involving WGTL. I have some questions I would like to ask, and you may wish to put it in writing, or you may wish to supply it in a summary form and to be followed by it being submitted in writing. From the records of Petrotrin, when was the first correspondence with our present Attorney General with respect to this matter issued since September? Because you did indicate, you see, I want to clear my mind, and I think the country would like to clear its mind on this whole matter. Another question I want to ask is, who was really responsible for the decision of the Board of Directors to discontinue this matter? When was the first time that the issue of discontinuing this matter considered by the board? When? Who advised the Board of Directors on this matter? What was the role, if any, of the Attorney General in advising the Board of Petrotrin in this matter? And I have two final questions that you can look at. Did the Board of Petrotrin consider getting a second opinion before making a decision to discontinue this matter? And if not, why not? And was the advice of the Attorney General to the board written or oral? As I said, these are matters that are troubling the nation. And we would like to have some clarification. You may not be able to provide us with all the answers today, but you may put it in writing, or you may wish to submit for our own consumption at this time in summary form your initial reaction. Mr. Chairman, I pause at this time.
Thank you very much. Mr. President.
Mr. Chairman, thank you. I don't know how to say it again, but I'll say it, right? That Petrotrin, maybe we can put it in context. Petrotrin is, in terms of its refining operations, there are at least 22 plants at Point of Pierre, which is a lot. So we run a very large refinery complex. GTL therefore would form one plant, if you will, in that landscape. And again, if you go back to the timeline, I took the time to reiterate that the last time we were here, the GTL facility would have been initiated with a project agreement around 2005. But even around that time, we were moving ahead with our gas optimization project. We're moving ahead with, subsequent to that, in the years that went on, to an ultra-low sulfur diesel project. We would have initiated a huge capital investment with respect to our Southwest Soldado facilities and the development associated with that. The point I want to make is that Petrotrin has been involved in a number of activities, all at the same time while the market continued to behave how it would with respect to prices. And during that time, we also experienced fluctuating refinery uptime and performance. And if you understood the model we started off with, you would appreciate that if we don't have the refinery uptime, then we are not likely to make the kind of profit we have to make. So to me, for us to suggest that the loss associated with the one project, while all the other projects were going on, is what would have impacted on employees' losses, is just to put it in context. We hear the question, and we certainly will, if again, through you, sir, it comes to us in a manner that we can respond to when we get it in writing. We will certainly make our best efforts to respond to it adequately. But that is the context.
Thank you for the undertaking on that, Mr. President. The committee will clean up the question and will submit it to you. Minister Antwine.
Mr. President, in your submission this morning, you spoke about challenges in terms of the staff, employees in Petrotrin. And in your submissions, I'm not too sure whether it is 39% of your leaders supposed to retire over the next 5 years or 39 of your leaders supposed to retire over the next 5 years. And in terms of your GIT program, you said that out of 483, only 69 graduates were selected. You mentioned your Petro skills and the other programs. Given the state of the economy and the state of unemployment and the increased retrenchment within the society, could you just give me a way forward for Petrotrin in terms of manpower and employee issues as the years go by?
Good morning again, Chairman. I think we need to look at the context, and the last time we were here, the question was asked with respect to competency. Based on the time, based on the challenges, what we have been doing is reviewing the organization competencies against what is expected to deliver. So, in the main, and following from the president, what the president lead, is that we've identified the two key areas, the upstream and downstream. Look at what is required together with all the support services, including any changes in technology. And we've been looking at our process maps, understanding the fact that we have a number of our highly trained professionals who we would possibly lose in the next 5 years. And a cadre of young persons based on our graduate training programs. And there was a lapse period, one, when we didn't really get involved in things like apprenticeships, graduate trainees, things like that. We've also had, when the industry picks up, we get a fair amount of poaching. So outside the local poaching, we've also had international poaching. So it has created some gaps for us. But what we have been doing is looking at that, looking at what are what is the gap between the competencies that we need and the competencies that we have, and how much of that we could close by in-house training, how much we could close by, and where the gaps are too far, we would have to find persons with some of those competencies that we could close quickly. But that's where we are. So it's a intensive exercise at this point that we are looking at, that we are reviewing the organization, understand the fact that we need to meet that challenge and look at reorganizing our resources in-house as far as we could to try to address that, understanding the fact that we could see further changes in the industry. But we also understand that this is cyclic, and it takes a fairly long time to create an operator on one of those plants, or to create an operator in E&P, or an engineer or a geoscientist that understand those structures. So understanding that, understanding the kind of training needs we have, it is really ensuring that while all this is happening, Petrotrin does not take a dip. That we continue to try to keep the refinery producing at the levels it is refining at this point, and also to ensure that E&P is producing at the levels that we so wish. And that's basically where we are. We expect, we have been able to get acceptance by the board of the top leverage processes. And we're now working those down. We have many of the process maps already, and there are not going to be changes in those parts of the company. And there are other areas that we may have had technology changes and stuff where we are now just reviewing those descriptions and looking at the training needs. But that's the exercise that we're in.
As we begin to wrap up, I have two more requested questions, and then we'll begin to wrap up. MP Karim, you have the floor.
Thank you, Mr. Chairman. True, if I could continue the question to Mr. Derek. through the President. With respect to the competence and the people aspect of it, because you can have a lot of technology and you can have a lot of the process mapping and so on, but if you don't have the required persons to perform the jobs, there's going to be a misfit, as it were, misalignment in terms of what the organization requires and what you have available. I just wanted to ask you whether you can give us some specifics as we speak today in terms of the number of senior or executive positions approved on your org structure and how many of those are vacant. In other words, if you had 100 positions that you have approved in your strategic plan or through your process mapping, how many of those are filled and how many of those you need to fill? And if you can tell us what you plan to do within which period of time. Now, one will argue as well that this is a downturn. You will find that the international scenario impacts upon what you're doing. But there's another argument in human resource development that this might also be an appropriate time for you to engage in investing in people, in training, so that when you require the requisite skills and competencies, they'll be there as you progress.
Through you again, Chairman. I think I accept totally what you're saying. At this time, we do not have too many gaps in the leadership, but a lot of the persons who are in those leadership positions and who have been acting and are replacements would exit the organization in around 5 years. So what we have is some gaps, but the timeline is short for filling them. And in that case, we need to get speed track training in some cases because some of those gaps have
Can you give us a sense as to the number? How many, what that gap really entails?
Well, we lose around estimated 931 persons in the next 5 years. And a significant amount of them would come from some of the key leadership positions.
Might you be able to give us a breakdown as to what that could look like?
So that we can provide that in writing as a subsequent when we get here.
Sure, if he's comfortable. Sure.
Can I ask?
I am very much aware of the apprenticeship program, as you know from my previous incarnation. And I recall when I would pass through the refinery, the public road that is on my way to school, you would have seen on that there's the Texaco Trade School, which is now replaced by the MIC Institute of Technology. And we in fact had signed an agreement with Petrotrin, I think within the last 2 years or so, in terms of providing apprenticeship type training for persons required on the plant. There's also another opportunity that we utilize, and I don't know if you're utilizing that at all. It's called the WAC, the Workforce Assessment Center concept, where people may have entered an organization with a certain number of skills and competencies, but may have acquired more on the job, but may have never been assessed to where they are presently, having acquired those competencies. I also know that you have a challenge with the plea and your store, and you might want to look at that in terms of your success rates and your contracted employees. I know it's really in form of a question, but the question should really be, to what extent are you going to be engaging in all of these multifaceted approaches to improving your human resource competence base?
And thank you again, Chairman and Honorable MP. I think when you had that transition from the trade schools, because you had most of the organizations at that time had their own trade schools, their own apprenticeship programs. There was the transition to MIC. I think one of the basic structure of the apprenticeship program was built, especially craft apprentice, around a first year of basic training, getting exposure into most of the trades, and then around 4 years on-site training. I think the organization, I don't know that the structure for transitioning from MIC into the company worked well. And in that regard, persons who came out of MIC didn't come into a structured 4-year on-site program that moved them from classroom, trade school exposure into actually being able to become tradesmen. And I think it is one of the things that maybe we had missed. I think the expatriates in the earlier companies understood that our education system at that time turned out a lot of young men around 15 with school leaving, and it made them, after a 1-year apprenticeship and 4 years on-site training, tradesmen. I think a lot of things have happened. We have had the introduction of a number of secondary schools that now graduate students with craft training, and I think that in some ways we had to play catch up. And our most recent intake of apprentices took some of those things into consideration, in that there's no longer the need for that first year trade school type arrangements, because we now have MIC and a number of the secondary schools. So we are focusing more now on getting the same type of people that you identified as assessors to work with these young people when they come into the organization, young males and females, when they come into the organization, to ensure that the training is structured so they could become the kind of tradesmen that we need.
I just want to help you with PLIAP.
Yes.
PLIAP is a very structured, it is something that we introduced. You might want to take a look at it.
Surely.
It's the Point Lisas Industrial Apprenticeship Program, where in 7 years, we're expected to turn out approximately 700 of these technicians and graduates who would have been spending considerable time, 6 months each, in 6 months rotation over a 2-year period on the plants. And I think Petrotrin is also a part of that. You may want to look at the
Yes,
PLI.
we are part. And we have done some work with that. Additionally, we have done some work with UTT. We now have a model plant in UTT for our operator training. So we have done some work. We've been working with the University of the West Indies. We are working with those institutions so we could build a lot of training around our professionals so that the institutes could help in terms of closing this gap. But we could share a lot of what we are doing with you.
Okay, thank you. Senator Bash, you have the floor.
Apart from the outstanding funds required for completion of the ultra-low sulfur diesel unit, what are the major challenges faced in integrating this plant with the rest of the refinery? We have read in the dailies that this unit may not actually work. If completed, the substructure may be prone to earthquake. Can you provide a complete picture of what lies ahead for Petrotrin, inclusive of full cost benefit analysis on the merits or demerits of completing this project?
Thank you, Mr. Chairman. I'll just give us all a general response, and then if the VP refinery needs to give more, we can answer. The ultra-low sulfur diesel facility, in our view, is important for the future of the refinery. We continue to sell refined products as our main product into our markets, and there is a growing requirement for ultra-low sulfur diesel by our customers, particularly within the region and otherwise. So for us, it is almost it's a question that answers itself in terms of why we need to have the plant. I don't think we have any concerns about the plant being able to integrate itself within the refinery. That for us, from a process engineering point of view, we have very little concerns around that. We think it will integrate itself when it's completed. We've had some challenges with the facility during the construction, and along the way we've had to challenge, if you will, the structural design associated with that facility, inclusive of things like seismic adequacy, etc. And that is what is before us. We are now doing a very detailed engineering feasibility study of the facility in terms of what is required for it to be completed. And our expectation is that when we receive that report, we will review it and continue with our activities to complete the facility and have it operational, we think, by the end of 2017, early 2018. In terms of our cost, the cost question will be better answered when we receive the feasibility study. It's important to know that the plant is about 98% complete in terms of its physical construction, and therefore what is required really is to do this feasibility assessment of our structural design at this point in time, determine what corrective actions need to be done, and then complete those corrective actions, commission the plant, and bring it online. And for us, we expect that is going to carry us into the next 2 years, if you will, right? And like I said, we have used end of 2017, early 2018 for that. In terms of cost, in terms of what will take to finish that, that will really fall out of the engineering work that is in front of us at this point in time.
Okay, my next question deals with the new headquarters building. I know we touched on it the last time, but we know that no action is being considered for the structure, given the current commodity prices. What happens if prices do not recover for the next couple of years? Are there plans to at least preserve the infrastructure, or are we just going to sit by and watch the steel beams rust and fall apart? Currently, this uncompleted building is an eyesore from the highway and diminishes from what the sense of pride in our state company. Has the company examined other, more innovative ways to complete the structure with minimum cash outlay by Petrotrin? And how soon will these plans come into fruition?
So, Chairman, certainly we share the view that it is a concern for us that the structure is on our compound and unfinished. But really, in the larger context of our priorities, we think that the decision to defer further activity on that facility is a valid one at this point in time. And certainly one that our board have accepted, and we continue to deal with that. We expect that in another few years, we will have to revisit the issue of that facility. We have, in the past, explored other options in terms of completing it, as you have suggested, by using partnerships, if you will, and other alternative ways. But given what is the state of the organization at this point in time, and I articulated a few minutes ago where our focus areas are at this point in time, we think that that is one that we can reasonably defer and pick up at a future date. And the intent is not that if prices stay low forever, we just do nothing about it. The technical advice seems to suggest that there's not a lot to be done in terms of preservation at this point in time. And we've basically, on the basis of that, said we think we have a period in which we can safely allow the facility to stand. And again, I want to reiterate, like you, we too share a sense of disappointment in having to see that facility all the time, especially from the highway. But that is just our reality. We have to kind of be a little bit more pragmatic and go past our feelings as management and leadership and focus on what is important for the company at this point in time. And again, we think that the 5 items we've identified and all that is associated with completing projects such as the ULSD and also getting production from places like Southwest Soldado is our priority areas at this point in time.
Thank you, Mr. President. Before I close, I just have a comment to the Petrotrin team, which is what should be avoided is throwing good money at bad. Thank you.
Thank you very much, Senator Bash. I have one last question, Mr. President, before we start to wind up. And it's something that was brought to my attention that I think is worthy of asking. In your submissions, it has been pointed out that there's been a significant escalation in the cost for an item called Directors and Key Management Remuneration. When we look at the data provided in your submission from 2006 to now, from 2006 up until about 2012, it was averaging about $6 to $8 million a year. In 2013, it went to $9 million. 2014, it went to $11 million. And in 2015, key management and directors' remuneration went to $29 million. So that we would just like to get an explanation for how it's virtually tripled from the average, especially at a time in the context, the frame for the question is that we're in a situation of low oil prices, really difficult situation for the company, and we have directors and key management remuneration increasing by almost 300%. so that we would like to understand what happened here.
Thank you, Mr. Chairman. We will respond to that in writing. We can always give you that detail and breakout of that course item.
We really appreciate that. Thank you very much. I think Senator Mark has Senator Mark.
Yeah, one final.
One final question.
Yeah, Mr. President, as the chairman said earlier in his contribution, we are here to help and not hurt Petrotrin. As one family, we are in the same boat. I would like to ask you if you would like to submit for the consideration of this committee recommendations to avoid the pitfalls that we have experienced as a company in the last few years. And how do we move from what we read in the papers recently, $1 billion in losses, if that is the fact? I am not too sure. You know, sometimes I get misleading information in the newspapers. But I read somewhere where Petrotrin lost $1 billion recently. How would you want us to help Petrotrin, given all the challenges that you are faced with? How can we work together to assist Petrotrin in avoiding some of the pitfalls that they have experienced? And maybe you can submit to the chairman on behalf of the committee some of your thinking and the company's thinking, management that is, and board, as to how do you go about, how does the company go about reinventing itself, reshaping itself, redefining itself, so that Petrotrin could return to the day of being a profitable state entity for Trinidad and Tobago. So I think that you could probably put that in writing and submit same to the chairman, because I think that we want to work with you to see what we can do as a collective to turn around Petrotrin.
Mr. President, it's fine. I want to just start to begin to wrap up by making one final comment before I ask you to give some closing comments. The issue that detained the earlier part of this meeting is one that we don't want the company to forget. And I think it was Mrs. Adar Singh who indicated that the company has certain obligations and some confidentiality issues. The Parliament is a confidential institution by nature. And while we understand you have obligations internationally, we want the Petrotrin to also understand it has obligations to the Parliament. And that in your deliberations about what is the next road forward in terms of the information requested by the committee, I want that to be part of your consideration, that while we understand fully you have obligations, but you also have an obligation to the Parliament, so that it's something the company may be wrestling with. And one of the easiest ways to deal with it, in my respectful view, is that the committee, in terms of any information is requested and there are questions, we can have an in-camera session to deal with those issues. And there's no issue with in my respectful view, about information coming to the Parliament and ending up elsewhere. That has never happened in my recollection. But I believe that the company has to be very clear in its understanding that as a part of your package of obligations, one of those key obligations is to the Parliament. So it is up to the company to work out a strategy to help everyone understand that, yes, we have confidentiality issues, you have obligations, but everyone needs to understand you have multiple obligations. So, Mr. President, with those few closing remarks on my behalf, I would like to ask you to give a few closing comments before we can draw the session to a close.
Thank you, Mr. Chairman. And through you, thank you to the other members of the committee for the questions and the comments that we received this morning. Let me conclude by suggesting to you, first of all, excellent thanks to my team who is here this morning and for the work that they have done in preparing for this session and the one before that, and for the hard work that they have done. We miss our chairman who is not here with us, but we understand that he's also involved in other activities. Let me say to you quickly, and certainly if I can, as I close, address that burning question that the Senator just raised about the perceived loss of Petrotrin last year. Petrotrin is not immune, if you will, to what is happening in the world market. And some of us seem to forget that other oil companies have suffered downgrades and have suffered losses given this very strange crude market and oil market that we're in at this point in time. It's very strange. It has not responded to what happened in Doha a few weeks ago, and everybody is still surprised at the level of where prices are at, and nobody can explain it. And so we are going through a very difficult time. Last year in particular, Petrotrin would have felt the brunt of what would have been a very precipitous fall in prices from when we started our financial year to when we completed our financial year. During that period, we have also been bringing a lot of plants online after the work that's been done on GOP. And so refining throughput is not as what it's been for the last 4 months. And so we would have found that we would have not been able to produce the revenue required, and therefore we would have experienced a loss. If you look back in the life of the company, there have been periods when during capital investment and construction in our refinery in particular, and given falling prices, we have experienced losses. But there are also periods, and that is what keeps us focused. There are also periods when the prices are buoyant and when our facilities are utilized to the fullest extent possible, where this company continues to create value to this country through its ability to generate revenue, cash, and profit, and also allow us to meet our obligations to the state in terms of our taxes and fees, etc., and continue the development of Trinidad and Tobago. Petrotrin does not need prompting to develop a new strategic plan. This deliberations that we responded to were based on a 2014 to 2019 strategic plan, as you asked us in your responses. We are at the point of completing a revised strategic plan that would look to the period 2016 to 2020. It would be discussed with our board, it would be presented to our line ministry and to the members of the shareholders and representatives through various committees, etc. We will seek buy-in from our various stakeholders, including our unions and other stakeholders, and our intent is to chart a path forward that is very focused and focus on the 5 items I mentioned to you already: building beyond compliance in our safety culture, achieving and ensuring asset integrity, running the company as a profitable business, dealing with our competencies with our people, and deploying the appropriate technology. We will build on that, and we will become a sustainable business enterprise for this country. The more we can educate and show people how this business runs, the greater understanding there is as to what is happening in the oil market and what are our advantages as an integrated oil company. We think the greater people are able to support us and to provide the required support to see us successful. That is all we ask. We ask for understanding for our context, and we ask for tolerance to allow us to ride through the bad times and support us through the good times. There are issues around corporate governance that we have returned this organization to focus on, and for that we ask no apologies, because we think it's important that we leave a legacy that is not dependent on who sits in the chair, but how the business is run. And for us, leaving proper procedures and the way we run the business is extremely important, so that 5 or 10 years from now, when another Petrotrin president and team appears before a committee such as yourself, they can account for good performance and not be going back on past mistakes, but because we have established a platform for sustainability. That is our mission. That is our focus. We want to thank you for giving us the time to explain to you what we are doing. We trust that through this mechanism, more people understand what we are doing at Petrotrin. We do not conduct our business in the public, but certainly like to educate people as to what we do and how we operate. And we want to give the commitment that we remain very focused on ensuring the sustainability and the survivability of this company going forward. Thank you.
Thank you, Mr. President, and thank you to your team for once again coming to this committee and being very forthcoming with your responses, both verbally and in paper. I want to thank the representatives of the Ministry of Energy for attending with us today. I want to thank the media, the observers in the public gallery, and the viewing and listening audiences in all the various formats that the Parliament has. And I would like to say now this meeting is now adjourned. Thank you.